gentlemen. My name...
Стоп, еще нет. Я не сказал go.
Okay.
Погнали.
So we can start, right? Great. Good afternoon, ladies and gentlemen. Today we are continuing our wartime specials webinars presented by Interlegal. My name is Mykola Kozachenko. I am an associate attorney at Interlegal Law Company. And today we will be talking about vessel sale and purchase deals. At the very beginning, of course, I would like to express our appreciation of our partner support, which are European Business Association, APK Inform, Dolphin Cargo Service, Interpars, English Law Report, Black Sea Institute of International Trade and Shipping Law, and Nautical Institute of Ukraine, who are our constant partners and friends, and whose assistance is very valuable in these times. So, as I mentioned before, we will be talking about sale and purchase of ships, some procedures which we adhere to, some checklists, and a bit case study of what we do here in Interlegal, assisting our clients. At the beginning, a few words about our company. Interlegal is an international law company specializing in shipping, transport, trade, and also we are doing legal assistance in corporate and taxes and yachting. We are international law company with our own offices in almost all countries of the Black Sea. We have 6 Black Sea offices and 30 associated offices all around the world, which helps us doing business worldwide in the shortest times and to be the most efficient. Our Black Sea offices are situated in Georgia, Turkey, Bulgaria, Romania, Moldova, and Ukraine. Few figures: we are long-standing international company with more than 25 years of practice. We count around 1,000 client cases per year. We have quite a big team with more than 60 experts in Odessa office, and also many experts in other offices around the Black Sea. And with that, we are coming to the point, to the sale and purchase of ships. This topic is especially important, valuable now when many traders or even some businessmen who didn't do anything with shipping or with international trade are now eager to start shipping business, because now it is quite profitable, of course, with some special particulars which they count before coming to this business. Sale and purchase deals are the starting point for starting shipping business, as it's logical that quite difficult to handle shipping business without having any ship. Sale and purchase deals are quite complicated ones, because they involve many aspects of commerce and law. They involve banks, governments, and various authorities, registration procedures. They require quite firm commercial experience and some commercial decisions. Of course, as each business is about money. Shipping is also about money, and sometimes these funds are smaller or bigger, but anyway, they are very important for those who handle this business. Sell and purchase deals also subject to various risks, and it comes to be one of the most crucial points in these deals. And of course, these deals are subject to law. And of course, we as lawyers mainly concerned on this part. And our main task is to find a balance between the law and the commerce, which is usually our client's task. For easier understanding and for some structuring of the deals, we can say that each sale and purchase deal consists of few stages. The first one is choice of the ship, then some pre-contractual stages, drafting contracts, pre-closing, closing itself, and post-closing procedures, which are necessary to proceed with the deal from the very beginning to the very end, which is preferably to be a successful one. So we will proceed one by one on these stages, and I will also proceed with some details to understand what we are doing, how we are assisting our clients, and what are the checkpoints to be considered by the client when they are just planning to be involved in this deal, and of course during the deal. So step one is searching the vessel for purchase. Every client has an idea what the ship should be, and the client, when the client is a buyer, he or she knows the purpose of that ship. So it may be either transportation of own cargo, or the vessel may be bought for transportation of cargoes of other parties. So there are options, but in any case, there are some particulars of ship which shall be counted. Of course, these are main dimensions like length, dead weight, cargo capacity, and so on, which allow us to understand where to look for the ship, and maybe which brokers we may involve, and so on. But this is the commercial part, and usually when we are involved in the deal, the client already knows the particulars of the vessel, which he likes, which he wants to buy or to sell, and only then a legal part is coming. And in each sell and purchase deal, the main requirement is safety, as a traditional motto for the shipping business. And when it comes to technical safety, that is traditionally the client's part, his technical department, or some outsourced company which deal with the technical part of the ship. But our task is legal safety of the deal and legal safety of the client during the deal and after its completion. In order to reach this safety, we have some brief algorithm for a safe entrance to a deal. First of all, the client and technical staff shall make a technical inspection of the vessel. It depends how deep this inspection will be. It depends on where the vessel is found, whether the seller is a known company or some stranger, let's say. but the buyer shall know what he buys and whether the technical condition of the vessel is suitable for the purpose. Then we also advise the clients to handle legal due diligence of the vessel in order to check whether the vessel is subject to any detentions, arrest, sanctions, claims, etc. Because after the vessel is purchased, it may appear that there are some debts, some reasons for arrest and detention, and depending on the country where the vessel is, it may be either enforceable against a new owner or not, but in any way the problems may arise and there will be a need to handle them. That's why it is better to avoid any risks related to such commercial history of the vessel. Of course, it is necessary to handle due diligence of the company. So when we are representing the buyers, we handle due diligence of the sellers, and vice versa. We need to know our client and our counterparty in order to avoid also any sanctions, any risks, any problems with payments, and so on. When it comes to sale and purchase of vessels, the frequent question is the payment scheme. There are many sources of funding purchase of the ships, and depending on each particular case, we shall understand what would be the payment scheme. Either it shall be a direct payment of the whole amount, or it could be payment in some installments. It may be payment with the help of the escrow agent or through the bareboat charter party or some other options. It also involves cases where the vessel is subject to mortgage and there is a registered mortgage, and payment schemes should also involve bank which holds the mortgage, and so on. Many issues which shall be handled before the contract is signed, because it is always better to understand the real situation with the vessel, with the payment, with options of transaction of funds, and outline them in the contract. Thereafter, it will be easier and more correct to proceed with this deal. And of course, compliance. This also corresponds to the bank compliance, because the buyer, the seller, they have their own banks, bank accounts. The transaction may be in one currency or another, and the banks shall proceed with compliance whether it would be possible at all to make such transaction or not. And of course, we are doing the same compliance procedures to understand whether there are any risks that the deal may have some negative issues. After that, when these preliminary stages are done, we are coming to drafting the contract. There are rounds of exchanges between the sellers, the buyers, between the lawyers of the sellers and the buyers, sometimes with the bank, with the escrow agent, and so on the terms of the agreement, which in the end of the day appears to become a valid contract which the parties begin to perform. Saying about the contracts for the sale and purchase of ships, we are coming to standard pro forms, which are used more frequently in the worldwide practice. So these are the memorandum of agreement under the sale form 2012 form, which has been used for a quite long time and is is the most frequently used one worldwide. We work with it all the time. And this year, BIMCO, an international organization, created its new form of the ship sale and purchase agreement with the code name Ship Sale 22. So we believe since now it will be also one of the instruments for the sale and purchase of ships. Of course, both these forms are standard ones, and they usually do not operate on their own, and they should be amended as per the parties' will. So we can either delete some provisions, add some provisions, or just change some provisions within the contract in order to outline the will of both parties, to outline the what has been agreed on, and to create a valid contract with full powers and all the details agreed. After the contract is signed, there are some points which shall be also done by the clients, by ourselves, depending on the terms of the sale and purchase agreement. Of course, the first point, which is very crucial, is the payment scheme. So whether performance of the contract requires any additional agreement, for example, escrow agreement. I will not stop on this point a lot, as it will be discussed a bit later. But in any case, when the memorandum of agreement, which is a sale and purchase contract, outlines the payment scheme, then we shall know how this payment scheme may be enforced. So whether we need to sign and agree any additional agreement, or there is no such need and everything is already outlined in the contract. Later on, both parties shall proceed with legalization of delivery documents. There is a long list of documents to be provided by the sellers and a bit shorter list of documents to be provided by the buyers, but they are crucial. Both parties shall prepare them, shall exchange them with another party in advance to get confirmation on the draft, and then proceed with its execution, legalization, and delivery to the place of closing. Another points are notices and inspections of the vessel, which are like more formal parts, but really necessary ones, as the sellers shall tender not preliminary notices of readiness of the vessel in order to find out when the delivery of the vessel is expected to be, as each party shall prepare itself, shall prepare documents, shall prepare change of crew, shall instruct its representatives to proceed to some place of closing to finalize the deal, and so on. And of course, there are points where the vessel may be additionally inspected, either by underwater inspection, or presenting the vessel in the dry dock to check its underwater part. The most important part of the deal, of course, payments, because impossible to proceed with the deal of sale and purchase without payments, and this part shall be done particularly in accordance with the agreement. Usually, the sale and purchase agreements provides a period within which payment shall be done, whether it is one installment or few installments, and period for each installment, where it shall be paid to, and so on. So each party shall control this part, shall check that they adhere to the contract and that the contract is performed in the due way. And of course, delivery arrangements, that is presentation of the vessel in the agreed place, arrangements of crew by the buyers, arrangements by the seller to change his crew, and so on. When all these preliminary steps are done and the performance of the contract is proceeding properly, we are coming to a closing, which is the finalization of the deal. What is the closing? The closing is a moment where the buyers and the sellers meet together or through their representatives and close the deal. It takes place when the vessel reaches the place of delivery, which is agreed in the contract, and usually meeting has few aims, which are checking of all the delivery documents, that they firstly correspond to the requirements of the contract and that they correspond to the drafts which were exchanged in advance by the parties. Then the payments are finalized. So the parties check whether all the payments were done, whether the whole amount reached the necessary account. If payments involve escrow agent or some letters of credit or so on, the parties shall give proper instructions to the holders of the money to finalize the payment. Then the parties, of course, shall procure the physical delivery of the vessel, that is transaction from the crew of the seller to the crew of the buyer, and sign their respective protocols of delivery and acceptance, either only one signed by the representatives of the parties, or there may be two protocols. One is protocol on legal delivery and another one on physical delivery signed on board of the vessel. But in any way, when these points are done, the deal may be considered as successfully closed, and legally the vessel has been transacted from the sellers to the buyers. But selling purchase of ships is quite interesting business, because after this part the deal is not fully done yet, because there are some post-closing arrangements which shall be done both by the sellers and by the parties. They mainly relate to the registration of the vessel for under the name of new owner, maybe change of the flag of the vessel, which shall be made in two tiers. First, the registration in the previous registry and registration in the new one. So we control this period, and if there are any issues arising at this stage, we may be also involved to find a solution of how the deal may be finalized in the interests of both parties, or if there are any disputes, claims, how to handle these matters. So the best picture for the lawyer and actually for the client is when after the closing, everybody is relieved and may proceed to its own business and not to worry about any further details. But of course, there are situations when something arises and the parties shall stand by and control the situation. But after the vessel is registered with a new owner, the deal is considered as completed and hopefully successfully completed. And now a bit like roadmap of how we usually handle these deals from other side. So what do law firms do, and in particular Interlegal, and especially with Interlegal as an international law company? So you may see that there are a few stages of involvement of lawyers, and each stage may be made and completed independently by some lawyer or some law company. There are some specials related to war times now in Ukraine, and here is a roadmap of some of our recent deals where our Ukrainian office was able to provide support during negotiations, to complete due diligence of company and ship, to assist the client with the bank compliance, to draft the contract, to develop a mortgage lifting scheme, to negotiate the escrow agreement provided by the escrow agent, to draft all the delivery documents, and to assist the clients in their execution, legalization, and to control that the payments are made. And as that war creates many restrictions in Ukraine, in the most recent deals, we were unable to represent our clients on closing meetings, but good for us. That's not a big issue, not a big problem, because we have professional colleagues from our Turkish office who can stand by and represent the clients at the closing to complete the deal. So we are working with our international office as one team, as one company, and each of these parts may be performed by either of our offices, but in the end, the whole deal is supported by Interlegal. So that is what we are proud of, and our value when we are coming to such international deals, which involve many international parties and also international travelings. Saying this, as I said, our international offices are highly involved in all the businesses we are doing, either independently or jointly with us. And at this point, I would also love to introduce our Turkish colleague, Ms. Celine Darendeli, who will tell you a bit about escrow agreements. As I promised, we will discuss it. So maybe it will also clarify some points for you and will be of interest. Celine, the floor is yours.
Yeah, thank you. First of all, thank you, Mikola. I'm Celine. I'm the partner of Dogulo Interlegal Istanbul office. And first of all, before coming to my presentation, I want to express my solidarity wishes with my Ukrainian friends and Ukrainian people. So please bear in mind that we stand with you and we pray for you and we pray for the peaceful times. So I hope the best for you. Now, let me speak about the escrow agreement. What is an escrow agreement? Let's start from this point. Escrow is an arrangement for a third party, but not for a reliable third party to hold the assets or funds of a transaction temporarily. The asset or funds are kept in a third party account and only released when all terms of the agreement, which is in our case the sale and purchase, in the sale and purchase transaction, when all the terms of the memorandum of agreements have been met. Why do we use the escrow account? it's simple because the use of an escrow account in a transaction adds a degree of safety for both parties, for sellers and buyers. Where do we use it? Escrow is commonly used for large transactions, such as vessel sale and purchase transactions, land transactions, or it can be used as a security in disputes, in legal disputes. How does it work? The buyer, for example, in terms of while speaking about memorandum of agreement or the sale and purchase of a vessel, the buyer transfers first the deposit amount, which is usually 10% of the purchase price, to the accounts of the escrow agent. And depending on the negotiations of the parties and the terms of the MOA, the memorandum of agreement, the buyer may also, in a later stage, at least 3 banking days before the delivery of the vessel, can transfer the 90% of the balance purchase price to the accounts of the escrow agent as well. And if all conditions are met, then the escrow agent will transfer the funds in line with the instructions of the parties. What are the main elements of the escrow agreement? Definition of the escrow deposits or the escrow balance, depending on the negotiations of the parties, which is written at the memorandum of agreement. Reference to the memorandum of agreement, of course, and definitions of the release events, which is highly important. It is clearly stated when the funds will be transferred to the seller's account, or if there is any surplus, the funds may go back to the buyer's account, or if there is any dispute between the parties, the escrow agent will be obliged to wait for the outcome of the unappealable court judgment or arbitration award. So this is highly important. Another important issue is about the parties. For example, we are also acting as escrow agent, and we are asking to the parties, who are they? And we are making the due diligence of these companies, of the sellers and buyers. And we are requesting some documentation from the parties, and they are answering us with their legal documents, of course. We especially under the obligation to investigate the beneficial shareholders to avoid the transfer of any illegal funds from sanctioned people. So this is highly important. Otherwise, the transfer and the transaction might be faced with some sanctions as well. Another important issue is the investigation of the escrow agent of the vessel's history. This is also something to be considered by the escrow agent when holding the escrow funds. If the vessel is banned somewhere, then the escrow agent will not be in a position to receive the escrow funds at the first stage. And then if somehow the funds are there, it will not be possible for the escrow agent to transfer it to the seller's account if the conditions are met. So this has to be diligently studied, the parties and the vessel's history. And another important issue, the parties, especially the buyers, the buyers should not forget to pay the escrow agency fees and the banking cost as well, because the escrow agent is not making an is not paying extra costs for and on behalf of the buyers. In fact, the escrow agent is not the attorney of the buyer. So it's a third party, it's an independent third party holding the funds for both parties. So therefore, for the buyers, do not forget to pay the escrow agency fees or the banking costs, especially when you are a buyer. Otherwise, you might be felt in the default position because the escrow agent will deduct his agency fees and the banking costs from the deposit amount or from the balance purchase amount. So the amount to be transferred to the seller's account will be less than the purchase price. So so we have to take, we have to make some, we have to show diligent, we have to be diligently while sending the funds to the escrow agent. So for now, these are the main issues about the escrow agreement and escrow services. And if there is any question, so I will be happy to answer these questions. Thank you very much for this.
Thank you, Celine. So actually, at this point, when you have discussed all the matters, what is the purpose of this topic is that we are highly concerned that the deal is completed safely and to the best interest of our client, and actually to the best interest of both sellers and the buyers. And we are trying to create win-win situations. And of course, one advice which we usually give our clients is to differentiate people and or representatives who are dealing with commercial part and with the legal part, in order the responsible people in charge could focus on their part. And of course, we are always here to assist in the legal part. At this point, thank you all for the attention. We do really hope it has been interesting and useful for you. If there are any questions, please feel free to write them down in the chat. We can answer them right now. Or if we see them a bit later, we could also reply them in written form. So if there is any private question, you can also tender it to us personally. At the moment, the only question I see is whether we see that our colleagues joined the meeting. Of course, we see, and happy you are with us at this time. And actually, I do not see any more questions. So once again, thank you all for the attention. You can see my contacts on the screen. So if there are any questions to me or to Celine, please pass them to me, and I will also invite Celine to join in replying them. Thank you once again, and see you later.
Thank you.